Good morning, everyone, and welcome to today's jointly hosted webinar by myself, Samantha Manning of Searches UK. And today we're kindly joined by Robert Kelly of Stewart Title. Please, could I double check that you can all hear me? If you can, there is a chat and a questions tab, so please do let me know that you can hear me loud and clear. During the webinar, if you have got any questions or you would like any information, or if you would like to ask any questions, please do use the questions and the chat tabs, and we'll be more than happy to answer any questions at the end of the webinar. Alternatively, if you'd like, you can contact myself or Robert. We'll give you our details at the end of the webinar. By all means, do ask any questions you may have or ask any further information. Just to make you all aware, the webinar is being recorded and everyone will get a copy at the end of today's session. What I'll do for now is I'll hand over to Robert Kelly. Thank you so much for attending.
Thank you, Samantha, and thank you to Searches UK for organising this webinar today, and to so many of you for joining us. I'll try not to dampen your New Year's resolution in excitement for education by being too dull today, but bear in mind it is conveyancing, so that's sometimes difficult. I'm very lucky because I qualified as a lawyer a long time ago, and I'm convinced there was far less law in those days, so it was easier than it is now. And certainly there are so many cases now coming forward, seemingly at a greater rate. And one of the benefits of not practicing anymore is that my phone doesn't constantly ring with unreasonable demands from clients or unnecessary requests for updates from agents. So I have the time to read and see about cases, and it is incredible the number of cases there are. And in the past year, there have been a number of cases about restrictive covenants from both the Upper Tribunal and the Court of Appeal. And that's what we're going to look at today, and also look at how these cases are relevant to you in the standard property transactions that you're dealing with. Restrictive covenants, obviously, as we know, cut both ways. And your clients will want to know and be concerned about how they can challenge the burden of a covenant and enforce the benefit of it. A couple of cases at the end of last year do deal with this. Once we've looked at these cases and the benefit and burden, then we can look at what you need to tell your clients about covenants, and also what you should be asking your client about their intentions for the property. Finally, we'll look at title insurance and how that can assist in some cases, and also look at perhaps how covenants may become more relevant in the future. Because litigation is an expensive process, the main cases on covenants tend to deal with large development sites or very expensive residential properties. The Holland Park case is a prime example of this. As you all know, the area of Holland Park is full of very expensive properties. It's the area of the London homes of the Beckhams and Simon Cowell. It's an area where Robbie Williams can shout over the fence to Led Zeppelin's Jimmy Page. Actually, in that case, they are shouting over the fence and shouting angrily and complaining about plans to build an underground swimming pool. Litigation is ensuing on that because they are both rich people. I'm looking forward to the case there. I do have my Let Me Injunct You title ready for any webinar we do on that. In the 89 Holland Park case, the designer Sophie Hicks owned a property and some land which adjoined a row of Regency villas, some of which have been split into very expensive flats. The freehold of 89 Holland Park was owned by a management company comprised of the owners of the flats. Hicks wanted to build a glass pyramid on some open land there to give light to a basement entrance. The owners of 89 Holland Park objected and referred to a restricted covenant that prohibited building without their consent. The court looked at who had the benefit of the covenants and what they were intended to protect. The lawyers for Hicks said that the management company was the freehold owner and had the benefit of the covenants reserved for the owner, and that therefore they were only interested in the effect on the residual value, the reversionary interest in the property. And it was agreed by all parties that the actual effect of these works would be minimal on that reversionary value. It's clear that that's legally correct, and that's where the benefit of the covenants went. But the court showed flexibility and explained that whilst the covenants covenants like this are obviously intended to protect the occupiers of the property and not just the ultimate landowner, the court saw covenants as a set of rules for how you live with your neighbours, and therefore the occupiers had an interest and were the relevant party in this sort of situation. Occupiers were rightly concerned over the day-to-day practical effects of development and not just the residual value. Here, the occupants of 89 Holland Park were concerned about the aesthetic effect of a glass pyramid next to an architecturally consistent terrace of stucco Regency houses, and also the environmental effect of the loss of established trees, which the development necessitated. Again, these are day-to-day practical matters. They're not solid legal matters. There is a degree here of judgment and personal taste in all of these. And it's interesting that the court was so willing to protect these. I think that's probably the lesson to take away from the Holland Park case for your standard residential development, in that if you have a client who objects to development by a neighbour, they can look at these more sort of soft and cuddly tests and in effect say that development just doesn't look right and therefore could be wrong, and you could have a right to object to it. I think that part of it is quite useful for residential properties going forward. The court threw back to the parties the issue of what changes to the works were required or what compensation was due to the objectors. Once again, the court was trying to allow people to develop land and to do so in a way that was neighbourly and respected the views of others. You'll be aware that there has been a general move by the courts when dealing with easements and restricted covenants that where planning permission has been granted or would likely be granted, the court shouldn't try and prevent development. Holland Park was a case from earlier in 2021 and which we have discussed in previous webinars, but at the end of last year, 2 judgments came which again show how the courts might look at enforceability of covenants going forward. In the Bath Rugby case, the court was looking at a covenant contained in a 1922 conveyance, so pre-1925 Land Registration Act, and the covenant prohibited development on land which was occupied by the Bath Rugby Club. The ground there is known as the Stoop, and is quite a striking site if you've ever seen it. It's basically almost like fields, a basin in between well-established old Georgian properties. Like many sporting clubs, Bath Rugby needed to redevelop their facilities to maximise income, and as is often the case now, redevelopment of a stadium doesn't just include putting up new stands, but almost always will involve other leisure or retail development. Again, given the nature of the stoop, you can understand how attractive a large undeveloped site just on the edge of Bath city centre would be to developers. But likewise, you can also realise that the owners and long-term occupiers of the neighbouring property have been used to looking out over effectively undeveloped land for a very long time and are likely to object. Restrictive covenants restricting development were included in the 1922 conveyance for the benefit of adjoining land or the neighbourhood, but no plan was included to show this land. Owners of the neighbouring property claimed that the benefit of these covenants were annexed to the neighbouring land. The initial court decision said yes, but the Court of Appeal held that there wasn't sufficient indication of what land was meant to benefit, so none of the adjoining owners could enforce. They also held that there was no further interest for the original covenantees in the land. Fortunately, the lawyer who drafted that covenant in 1922 is now well gone, but the essence of the judgment is that the lawyer got it wrong. Why didn't he, and in 1922 it would almost certainly have been a he, why didn't he put in a plan? Why was there such a vague wording? It seems rash, if nothing else, to actually try and protect land in that way without actually including a plan and clear definition of the land involved. The end of it is that Bath Rugby Club will now get a new rugby ground unless it goes to the House of Lords, and the neighbours will have a large development at their back windows. This could have been prevented if there had been clearer drafting. As I say, the lawyers who drafted the Bath Rugby Club covenants now long gone, but the lawyers who drafted the covenants in a 2001 transfer discussed in the Father's Field case are more exposed and quite conceivably are now sweating in a very unprincely way over the decision of the upper tribunal in this case. Here, a transfer of a site included a restrictive covenant not to construct any residential development without the transferor's consent until after 2031. That probably seemed a long way away back in 2001, but doesn't seem so remote anymore. The current landowners wanted to develop, so made a Section 84 application to discharge the covenant as it didn't protect a substantial benefit for the transferor's land. The upper tribunal agreed with this and said that it didn't protect any benefit or value as the transferor didn't hold any land nearby and was simply an overage provision and not really a covenant, as it didn't touch or concern the land. Again, it's tempting to try and work out why the lawyer in this case decided to draft it in this way, whether they thought it was a clever way of hiding overage in a restrictive covenant, or simply that they didn't really think about what they were trying to protect. However, there was no doubt that the transferor there was attempting to share in the development value of the property, and if it seems likely this won't be possible through the overage provision, then he may well be looking to the lawyer's PI policy to make up any loss. It's also worthwhile remembering that whilst overage provisions are often difficult to agree with landowners, and that may be the reason why they try to hide it here. They are better than restricted covenants in many ways because Section 84 doesn't apply to them. So you can't apply to the court to vary or alter an overage provision. It is a contractual obligation made between parties. In both the Bath Rugby Club case and the Father's Field cases, the drafting was poor and didn't protect what it was meant to protect. Those simple basic rules of drafting: understand what your client wants and make sure you express it clearly and simply, apply to restrictive covenants as to any other drafting. With restrictive covenants, you're laying down a test which will be operated in the future. It can be almost a century later, as in the Bath Rugby case, or 20 or 30 years later in the Father's Field case. It's likely to be operated by new parties who weren't there at the original drafting, so it needs to be clear and concise. We probably don't, in normal residential sales and purchases, talk about including restricted covenants, and actually where covenants become an issue is where our clients are buying a property and we need to explain to them the effect that restricted covenants will have on their use of the target property. Again, I think that when I was practicing, we tended to take a fairly relaxed view over covenants, as it was assumed that most residential owners would be leaving the property exactly as that. We didn't imagine many of them deciding to run a tallow makers or to boil down bones in a suburban semi, or to breach temperance covenants so often put into back-to-back developments in industrial towns. But now I think things are changing. We are in an age of working from home, of micro businesses, startup businesses. So I don't think we can be so certain that our clients won't want to know about these restrictions in the title. They may think that the land is theirs, in the way as an Englishman's home is a castle, and they won't understand or won't expect there are restrictions. We know that cases tell us that it's not sufficient just to give a client the registered title and tell them to read it. So as a minimum, I think we need to isolate restricted covenants and give some indication of what they do and what they prevent. Part of the process, I think, of reporting on title and communicating with a client is to understand what they might want to do with the property. Are they buying a house with a big garden because they think they can build a home office in the garden? Are they looking at the large garage as a perfect granny flat? There are, of course, limits on time and how far you can go as a lawyer in asking questions, but I do think that probably if you don't ask, well, I think for certain, if you don't ask and the client has a problem later, then you can expect trouble from them, whether that's successful or not. If you do identify a covenant, which may be an issue, then you do need to look at what comfort you can get from the seller. Obviously, if the breach is already existing, we need to know the history of it. If there have been breaches in neighbouring properties, again, we need to know about that. Has there been any disputes with neighbours over use of the land? Have there been any agreements reached on other properties or informal or formal agreements with neighbours? We need to know about these. And also we need to think about documenting that knowledge. Are replies to inquiries enough? Or should you be looking at something more substantial that you can rely on in proceedings? certainly the seller will be keener to help you when the sale is dependent on it than after completion. So I think you should try and get the evidence from the seller at the time. Get the best evidence you can whilst you have that advantage of the negotiations. And potentially, whilst it is, of course, difficult to legally enforce future performance by the seller, you might want to include an obligation on them to assist if proceedings occur in the future. And anything you can do there is helpful. What may appear now to be an academic problem may become a real legal dispute in the future. So, if there is an existing breach, if your client confirms that it's intending to breach the covenant, can title insurance help? While I'm contractually obliged to tell you that it can, but actually genuinely it can help and should certainly always be considered. Probably some of the most common inquiries we now get from solicitors are regarding restricted covenants, particularly ones regarding intensity of development on a piece of land. And we're always ready to discuss those with you and to see if title insurance is available. If your client needs to get planning permission for the works they'll carry out, then it is possible to get insurance both pre and post planning, but obviously the premiums for pre-planning will be higher. We now can look at, and insurers are offering two-stage insurance, which means that you can get pre-planning cover against costs incurred and then have the certainty of there being an insurance policy there afterwards to cover the breach. Bear in mind that merely getting planning permission doesn't deal with the covenants, the breach in the future. And indeed, as you may be aware, there have been cases in the last couple of years where a local authority has granted planning permission with its planning hat and then objected to use of the land with its landowner hat. So whilst planning is going to help you, it's not the end of your need for a solution to the dispute. If you're going to an insurer, obviously the more information you can give, the better. They'll need plans of the development, information about the covenants, any previous or existing breaches, any similar breaches in the area, and details of any planning objections. The fact that covenants have been breached in the area isn't of itself definitive that a successful claim can't be made, and indeed we know there are cases where landowners have consented to changes in restricted covenants in the past, but are then successful in enforcing them against future owners of other properties. However, title insurers do like to see this and take comfort from it. So the more information you can get, the better for you and the easier it will be to get your policy. Obviously, make sure that the insurance you get actually covers the risks that matter to your client. Don't assume that you know what your client's concerns are. And also make sure that the policy covers legally the issues you're concerned about. We have had a few cases where cover has been purchased to cover covenants in a particular conveyance or specific transfer, and then a claim is later made in respect of covenants in another transfer or conveyance. Also, when you're talking about title insurance and talking to your client and explaining it to them, bear in mind what they're concerned about. Title insurance in its normal form covers the diminution in the market value of the property. However, that may not be what your client is concerned about. They may be more worried about abortive costs if somebody objects, or they may actually think that if they can't have certainty that they're going to be able to use that property to build that Home Office to convert that granny flat. They don't want the property. So do explain to them that title insurance is a financial compensation, and it doesn't necessarily mean they will be able to do what they want to in the future. As a final point, I think it's worthwhile remembering that since the post-Second World War planning regime came into force, homeowners have been able and encouraged to use the planning system as the best way to comment on and influence development in their neighbourhood. Permitted development rights have grown over the years, taking some development out of the planning system, and this has been increased dramatically by two acts which were brought in since the start of the COVID emergency. There have been attempts to challenge the effect of this legislation, but so far legal challenges have failed, and it looks like a great deal of development is now being taken out of the planning system. Some of this development is extreme if it's happening in the house next door to yours. Freeholders of residential developments of 3 stories of flats or more can add 2 further stories to the building without getting planning permission. Similarly, you can add to the side of your property to add extra bedrooms and rooms to a property without it going through the full planning procedure. Therefore, if we're not able to challenge it in the planning system, I think that your client will want to know what rights they have in their title deeds to prevent or influence this sort of development. Hopefully, if the courts continue the tone set by the Holland Park case, then aesthetic and environmental factors will be useful objections and probably are easier for you to argue and to prove. Nearly all development by its nature will have an effect on the environmental pleasure and enjoyment of properties, so it is something to bear in mind. Also, if you have the benefit of covenants, it probably increases your negotiating strength in any discussions with your neighbours about what needs to be done about the development they're proposing. So it is useful to have those there as negotiating tools going forward. That has been a rather quick run through of these cases, but I think it does show the way the courts are looking at enforcing covenants, and also the important lessons for us as conveyancers to learn that actually we need to get the drafting right. We need to understand what we're protecting, who we're protecting, and making sure it works in the future. So, Samantha, I don't know if we have any questions so far.
At the moment, no, we don't, Robert. However, Robert's contact details are on the screen now if anyone would like to ask any questions. Oh, no, we have actually got a question come in, Robert, if that's okay. Do you have some time?
If it's not too difficult, yes.
Perfect. No. So the question from one of our attendees is, are you aware of any case law defining one family?
Yes, there is some case law on the case law I've seen tends to be a bit contradictory. But if you want to send me the details of the person, I can go away rather blabber on now.
Absolutely.
Try and find some case law on there for them. But it is certainly, it's one of those cases where it appears to be contradictory. But I think I can help there if you send me the details.
Brilliant. That's absolutely not a problem at all. So attendee, just to let you know, I'll send Robert Kelly your information and he'll contact you directly after today's session if that's okay. So what I'd like to say is thank you so much, Robert, for hosting today's webinar, and we would like to thank all of you for attending. We understand that you're all incredibly busy at the moment, and we appreciate you taking the time to join us today. I just wanted to let you all know that HM Land Registry and Searches UK have teamed up to host a series of free nationwide seminars. The seminars will be taking place in London, Manchester and Nottingham. So if you have any questions that you'd like to raise to HM Land Registry directly, now is your opportunity. If you'd like more information or if you'd like to book on to one of the seminars, you can go to our website www.searchesuk.co.uk/events/category/seminars, and you'll be able to book on to any of the seminars that we've got upcoming. The details are on screen, and the dates and times of these seminars. We'll hopefully see you soon. Thank you so much once again for attending, everyone, and I hope you have a great day. We'll see you soon. Take care. Bye.